illustrious career in civil and commercial law as well arbitration. Mr. Acharya has extensive experience representing clients across multiple jurisdictions, including Delhi, Rajasthan, and Mumbai. His expertise spans a variety of disputes and litigations, including real estate, investment agreements, partnership disputes, cases with governmental authorities, insolvency and bankruptcy matters, and family disputes, among others. In addition, Mr. Acharya has represented clients in numerous domestic arbitrations and regularly appears before the Supreme Court, various high courts, commercial courts, consumer forums, arbitral tribunals, the National Company Law Tribunal, and the National Company Law Appellate Tribunal. Today, Mr. Acharya will provide us with a deep dive into personal insolvency under the IBC and the emerging jurisprudence surrounding it. We will also discuss the landmark judgment Dilip B. Jivrajka versus Union of India, a case that clarified the liability of personal guarantors under insolvency proceedings and reinforced the legal framework for personal insolvency resolution. Before we begin, I would like to inform all participants that there will be dedicated question and answer session at the end, so you can unmute yourself and ask the questions. Now, without further ado, let us welcome Mr. Siddharth Praveen Acharya to take over the session. Sir, over to you.
Thank you so much, Aishwarya. Thank you so much, Saul, for having me, Akshay, for having me here. And I just saw a text popped up कि हिंदी में भी समझाने के लिए बोला है. So if you allow, shall I keep the mode as bilingual of this lecture? I keep it in English or Hindi, जैसा आप लोग कहें.
या श्योर है. आप बाय लैंग्वेज कर सकते हो.
बायलिंगुअल, ताकि एटलीस्ट क्या है कि
Yes.
जो स्टूडेंट्स जिनको थोड़ा मतलब इंग्लिश में इशू होगा वो now I got a text that it says that you have to give it in English. Anyway, so what I'll do is, okay, fine. So what I'll do is I'll make it in such a way where it will be easier for both the people to understand. Even if you don't understand, no problem, no problem. I'll keep it in English. And in between, I'll also explain the intricacies of the code and the subject in Hindi as well. I'll keep it. Okay, that's fine. Anyways, so let's start with today's topic. Today's topic actually is a very important topic right now in the entire insolvency landscape. The IBC is now almost a decade old code. It got enacted in 2016. Today, now we are in 2025, and there have been sea changes. There have been a lot of reforms that have taken place over the years since the code had come into the picture. Since the inception of the code, there are multiple reforms, multiple amendments that has happened in the due course. And today, as we are talking and we are discussing this subject, today's topic, like I told you, personal guarantor to the corporate debtor. In layman language, we call it PG to CD. The PG to CG is a very important concept, and especially in the past 3-4 years, you have plethora of judgments, including Dilip Rajka, which we'll be discussing, G Rajka, which we'll be discussing. But apart from that, there's a Mahindra Jajodia judgment, there's a Lalit Kumar judgment, and in the course of the lecture, we will be discussing all of them. And what challenges today PG to CD petitions are facing, that is also something which we will be discussing in the due course. Now, what happened was, as you all know, the IBC as a code, when it was enacted, at that time we had Finance Minister Mr. Arun Jaitley, who was at the helm of affairs. And insolvency and bankruptcy code had come into the picture because somewhere the legislative people, the lawmakers realized that the predecessor legislations like RDDBI, the Recovery of Bank Debt and Due, which is also called as a DRT Act, also apart from that, Sarfasi, they were not able to, realize the value with the objective with which those laws had come into the picture. So on the basis of the failure of the predecessor acts, the government decided that now we have to come up with a law, with the legislation, or with a code, the group of legislations, which will have an overriding effect above all the preceding laws. And at the same time, the law has to be implemented in a time bound manner. And idea was also not the recovery of the money, because for the recovery you already had a safasi. The idea was also to rehabilitate and revive the sick companies, the companies who are under genuine distress. So any law which comes into the picture, which comes into the effect, always comes up with a noble intention. Here also, when the first draft had come, when the law had became a reality, at that time, there were many lacunas in the law per se. But at the same point of time, the intent of the legislators was to ensure that we have a law in place which helps to maximize the realization for the creditors. At the same time, you also have a law which ensures the rehabilitation and revival of the sick companies. That also is called as the which is also laid in the preamble of the IBC. Now, what happened was eventually a lot of NCLT proceedings had happened. The petitions were admitted. There were successful resolution applicants who had come into the picture, who had bid for, for the corporate debtor properties. But eventually, what started happening was that there were very few cases in which the company had actually gone for the resolution process. Ultimately, what started happening was that the most of the companies started going through the liquidation. Now that became a kind of a contradiction, because, like I told you just before, that the original objective was the maximization of the value for the on behalf of the financial creditors and as well as the operational creditors. But however, due to the law being law and the tendency of promoters and corporators to misuse it, and also a lot of promoters started fronting themselves, their relative or their own companies, in the garb of someone else, and they started again reacquiring those assets at a very low price. So just to make someone understand in Hindi for a moment, कोई भी चीज जो डेट में है, जो डेटर है, वो डेटर की वैल्यू उसके पास में, लेट्स से आज की तारीख में 100 रुपए का उसके ऊपर उधार है, लोन है, उसकी कंपनी उसके एसेट्स एनसीएलटी में, एडजुडिकेटिंग अथॉरिटी में, वो एडमिट हो गई उसकी पिटिशन, तो कंपनी एक तरीके से मॉरिटोरियम में आ गई. मॉरिटोरियम का मतलब यह है कि इट लीड्स टू अ सस्पेंशन ऑफ ऑल द एक्टिविटीज. वो सस्पेंड होने के बाद में जो सीओसी बैठती है, कमिटी ऑफ क्रेडिटर्स बैठती है, सीओसी में 66.67% वोट लेने के बाद कोई रेजोल्यूशन एप्लीकेंट आया. अब प्रमोटर ने अपने किसी जान पहचान के आदमी को आगे करके वो सेम चीज जिसमें उसको 100 रुपए देने थे, उसने किसी को फ्रंट करके 40 रुपए वापस देके वो कंपनी और वो एसेट्स वापस ले लिए. तो इट बिकेम मोर ऑफ अ फ्रॉड. तो ये दो तीन चीजों को देखते हुए, when it was observed, there was a section 29A which basically establishes the eligibility criteria of a resolution applicant. वो इंट्रोड्यूस किया 2018 में पहले आईबीसी अमेंडमेंट में मिस्टर अरुण जेटली ने. और भी काफी अमेंडमेंट थे, बट I don't want to digress from the main topic today, because our today's topic is more on the personal guarantors. But I'm just giving you a bit of a foundation, how the law came into the picture, how initial 2-3 years were there, and then what led to the invoking of PG to CD by the financial institutions. Now, what happened was, जैसे मैंने आपको example दिया, the way I gave you an example, that their realization became little less, and in fact, banks also started getting a lot of haircut. So in the haircut, what happened was, bank, let's say they have lended around 100 rupees, but ultimately when COC used to sit, when the resolution plans used to come, even in the best plan, in the best case scenario, they only used to recover 30 to 40% of the amount on average basis. So this again crippled the economy, because ultimately the objective was, sorry. Raising the objection. Yeah. Yes. I'm sorry, there was a technical difficulty.
No problems.
Yeah, I'll just resume this.
Yes.
Just exit. Yeah. So the thing was that now you have a resolution applicant and the committee of creditors, which also includes banks and other creditors जिन्होंने lend किया है पैसा उस company को और उस corporate debtor को. Now they were not able to get the realization. The realization was only up to, let's say, 35 to 40% on an average basis. So now what happened was, like I told you, the main objective of the code was that the banks can have a maximum realization from the value of the properties which the corporate debtor has mortgaged. So when they were not able to raise funds, when they were not able to sell it, or maybe they were not able to get a resolution applicant who was able to bid at a higher rate, that again defeated the entire purpose of the objective. So when it defeated the entire purpose of the objective, the only sole thing which they had to only the cause they had which on which they could from which they could again get their money back was only this provision called PG to CD. Now the section 95 to 100 under the Insolvency and Bankruptcy Code deals with it. Now, this is again Dilip Jirajka judgment is a landmark judgment which had upheld the constitutionality of section 95 to 100 in the code, because before that what happened was we had a provision, but at the same point of time, before Dilip G. Rajka versus Union of India. It is a November 2023 judgment. You can Google. Dilip G. Rajka judgment is also the landmark judgment in which Supreme Court had assailed and had upheld the constitutionality of the personal guarantors provisions of the IBC, of the Insolvency Bankruptcy Code. I am coming on to that, what provisions are generally dealt with. What provisions are dealt with, and at the same point of time, I'm also going to be getting into every single section which deals with it. So Dilip Jirajka's judgment actually petitions that were filed, because somewhere the concerns of the promoters was that when we already have a corporate insolvency resolution process going against us, then why is there a need for a separate provision that can be invoked by the bank? The reason why it happened was because, like I told you, the banks and the financial institutions were not able to realize the value. So they said, okay, whatever amount we are not getting by putting the company under the CIRP process, now we are going against the properties of the personal guarantors who actually had claimed the guarantee, who had entered into a contract of guarantee with the principal debtor. So as I'm pretty sure that most of you under your Contract Act has studied section 126, the contract of indemnity and also the contract of guarantee. So usme there is a principal debtor, there is a guarantee, and their liability, both their liabilities are coextensive. I'm pretty sure that you must have studied that. So that is exactly the same thing in which they understood that in case if the debtor is not able to pay us the amount which we want, we are definitely going to go against the properties of the personal guarantor. Now, in this, Dilip G. Rajka's judgment, in Dilip G. Rajka's case, the petitioners came and they raised this question that now which immediately comes into the effect when any financial institution or any creditor goes against a corporate debtor. So petitioners felt that this is a very unjust thing because you cannot give sweeping powers to the resolution professional. Now, the resolution professional is the same person who is earlier called as interim resolution professional when CIRP takes place. But here, he takes over the account as a resolution professional. So the resolution professional technically is the CEO of the company after the erstwhile board gets suspended in the moratorium. So personal guarantors felt that now we had just lent money. We were just the guarantors in the place. And being a guarantor, our assets are also under threat. For what reason? So on that, many promoters or many guarantors actually went to the court, but at the same time, Supreme Court assailed that in even under the court have the right to initiate the interim moratorium. So thing is that the whole power, the sweeping powers of the resolution professional, they were not upheld because at the same point of time you already had a Swiss ribbon judgment, which is again a very important landmark judgment in the IBC landscape, which already had spoken about that the resolution professional does not have the adjudicating authority. He doesn't have the adjudicating power. He only has administrative power. And his opinion is recommendatory in nature. So he is somebody who cannot have sweeping powers of investigating into the accounts of the guarantor, into the accounts of the promoter when a personal insolvency case has been initiated. So these are the issues which were generally dealt with. Now we'll go each section by section. What were the important observations of the Supreme Court? To understand that the functions of a resolution professional in CIRP process vis-a-vis to a function of a resolution professional in a personal insolvency case is a little different. So on that, the court held that while both part 2 and 3, the part 3 basically talks about the personal insolvency and part 2 talks about the corporate insolvency resolution process of the code uses the expression resolution professional. Notably, the provisions of part 2 contains a material difference from those of part 3 relating to the roles and functions of a resolution professional, which I just told you. Second thing was the role of resolution professional under part 2 has to be contra-distinguished from the role ascribed to him in part 3, as in part 3 he is appointed for the purpose of resolving insolvencies and bankruptcies for individuals and partnership firms. So part 3 made the responsibility. Yeah. So the point is that the court held that it is a contra-distinguished functions which both have because part 3 generally deals also with the partnership firms as well as the individuals. So here the objective of the resolution professional is only to deal with the insolvencies. But however, in part 2, in a corporate insolvency resolution process, his power is more like a de facto CEO of the company, because when the board is suspended, his authority is also to collate the claims. His authority is also to ensure that company, when it is under moratorium, the essential services have to be provided to the company. So basically, it involves salaries which have to be paid to the workmen, salaries which are paid to the lower person in the pyramid of the company, and also other things in the times of COVID, in the times of any natural calamity, the company still has to function. Like I said, the objective is again the revival and the rehabilitation in ensuring there is a maximization of realization. Again, the whole objective of court is not to stop the company or to bring the company at the halt. Third is, in part 2, the adjudicating authority is also contemplated to have an adjudicatory role right at the threshold. In contrast, in chapter 3 of part 3, the appointment of a RP is contemplated by section 97. And under subsection 5 of section 97, AA has to appoint the RP who is either recommended under subsection 2 or nominated by IBBI under subsection 4. So the point is, again, at prima facie, the role of a resolution professional can be adjudicatory at first instance when a CIRP is initiated. But here in personal insolvency case, that is not the same. Fourth thing was, evidently subsection 3 operate on the RP alone and cannot be construed to be a bar. You are the adjudicatory function of the AA under section 100. The RP is empowered by subsection 4 of the section 99 to seek further information or an explanation in connection with the application from the debtor, creditor, or any other person who is in the opinion of the RP may provide information. The information which the RP is empowered to seek act as an aid to his duty to examine the application and submit a report, either recommending the approval or the rejection of the said application. In other words, the information which the RP is permitted to seek acts as a bridge that facilitates the RP to discharge the functions conferred upon the RP. So basically, again, the whole idea is to ensure that all the claims are collated properly, in which RP doesn't have a sweeping power or a sweeping authority in terms of poking the guarantor who has been involved. The RP is also required to examine the application as per subsection 6 of subsection 9. We'll be reading all the entire sections again after some time. But at the moment, I'm just giving you the crux of what this observation actually is trying to convey. So firstly, the application satisfies the requirement of section 94 or section 95. And secondly, the applicant has provided the information and furnished. The RP may either recommend the acceptance or rejection of the application. So again, the whole thing talks about how the RP is going to be acting. The role of resolution professional is also act as a facilitator and is to gather the relevant information on the basis of the application submitted under section 94 or section 95. Significantly, there was a very important development. The statute has used the expression examine the application and ascertain and satisfy the requirements and recommend the acceptance or rejection of the application. The use of these expressions leaves no manner of doubt that the resolution professional is not entitled to perform an adjudicatory function or to arrive at any binding conclusions on facts. Rather, the role of RP is purely recommendatory in nature and cannot bind the creditor, the debtor, or the AA. So here, what they did was they basically established that there has to be a very harmonious relation between a debtor and a creditor. So here, the sweeping powers were not given to the resolution professional. His views were only held to be recommendatory in nature. It doesn't give any kind of an edge to the RP above the other stakeholders who are involved. Now, again, another thing which again was a very important issue that was dealt was again the initiation of the interim moratorium. So a lot of guarantors felt that just because a personal insolvency process has been initiated, one cannot have an interim moratorium initiated immediately, because in CIRP cases, until the adjudicating authority doesn't admit the petition, your moratorium doesn't come into the picture. It takes 2 weeks for moratorium to get enforced. Sorry, 1 week. But here, the moment you file the application, your interim moratorium process starts. So the petitioners felt that somewhere it is challenging the principle of natural justice. This is absolutely violation of Article 14. And in some way or the other, you have given creditors more power above the debtor, above the guarantor. So the court held that in terms of section 96, the interim moratorium takes effect on the date of the application. In other words, the very submission of an application under section 94 or section 95 triggers the interim moratorium, which ceases to have effect on the date of the admission of the application, like what I just told. The consequences which flow from an interim moratorium are specified in clause B of subsection 1 of section 96. The impact of the interim moratorium under section 96 is that a legal action or proceeding pending in respect of any debt is deemed to have been stayed, and the creditors or the debtors shall not initiate any legal action or proceeding in respect of any debt. So the crucial words used in both the clauses, clause B1 and clause B2 of subsection 1, are in respect of any debt. Now, these words indicate that the interim moratorium, which is intended to operate by the legislature, is primarily in respect of a debt as opposed to a debtor. Now, this again must be contradistinguished from the provisions of moratorium contained in Section 14 in relation to the CIRP under Part 2. The moratorium under Section 14 operates on the order passed by an AA, like what I just said. The purpose of the moratorium under Section 96 is protective. Now, here they are trying to protect. The objective of the moratorium is to insulate the corporate debtor from the institution of legal actions or the continuations of legal actions or proceedings in respect of the debt. So the government, the respondent who was arguing the case at that time, I was also personally part of this case, and we had also moved an interim application, intervenor application on behalf of a resolution professional in the matter. So somewhere the respondent also tried to say that the moment we are putting an interim moratorium on the corporate debtor and the guarantor, at that time, we are again also trying to insulate them from any other kind of a legal proceeding that can come subsequently. It was a good argument that was brought by the court at that time. And court also felt that yes, this needs to stand. And this section again is constitutionally right. It is not ultra vires of the constitution. And it again stands on all the golden triangle of Article 14, Article 19, and Article 21. Again, the role of the adjudicating authority was again examined, and again the most important part was the principle of natural justice in this, because somewhere they felt that even without hearing our stand, what role guarantor is playing, up to what extent the guarantor is involved, nothing was examined, and before that they're trying to give powers to them. Now, again, there is a very important expression. The expression may require the debtor to prove repayment of the debt implicates the role of the debtor in explaining whether, as a matter of fact, the debt remains unpaid or has been paid. The RP cannot decide the issue in absence of an opportunity to the debtor to furnish an explanation and to produce material evidencing the payment of the debt. Likewise, subsection 4 of section 99 to empower the RP to seek further information or explanation in connection with the application from the debtor. So the role of the resolution professional was again and again questioned, as in up to what extent they have the power in connection with the application. Again, they felt that the judicial oversight is somewhere very much there. And the section 95 to 100 doesn't need to have that kind of a judicial oversight. So Supreme Court observed that an adjudicatory role interposed at the stage of section 97 cannot be accepted. The power which is conferred on the adjudicating authority, which is NCLT in the case of a company, and it is DRT in the case of a partnership firm and an individual firm. The power which is conferred on the AA at the stage of filing of an application is to appoint a RP. The purpose of the appointment of RP is a facilitative exercise which ends with the report either recommending the acceptance or rejection of the application. Bearing in mind the statutory scheme, it would be impermissible for this court to allow for any kind of an adjudicatory intervention of the AA in adjudicating what is described as a jurisdictional question at the stage of section 97.5. So again, the whole point is that they have a very limited role to play, and there cannot be a unnecessarily judicial oversight that was argued. But the court also held that there cannot be extreme judicial oversight, but at the same point of time, it would be impermissible for this court to allow for any kind of adjudicatory intervention of the AA in adjudicating. So somewhere they also had put a rest on ultra adjudication by a resolution professional in these kind of matters, and at the same time by adjudicating authority in these kind of matters. Now, what was the role of the adjudicating authority? That also was explained by Supreme Court. Supreme Court felt that section 101, it stipulates that the adjudicating authority must issue an order within 14 days of receiving the report, either admitting or rejecting the application filed under section 94, 95, depending on the circumstances. Adjudicating authority conducts an independent assessment, not solely relying on the resolution professional's report, to decide the fate of applications under section 94 and 95 of the code. The entire scheme of section 99 and 100 implicates timelines laid by the parliament, and it would render nugatory if an adjudicatory role were to be read into the provisions of section 97.5. Like I told you in the beginning, everything has to be time bound. However, it's because of a lot of judicial intervention in the IBC. the timelines are not followed, which is a very unfortunate part about the code, because this code is not a normal law. It is a lex specialis. It is a special law which was enacted, which was codified with an intent that the resolution is going to be a time-bound process. But unfortunately, what happened was, it's like what happened in the Arbitration and Conciliation Act, or what happened in other special laws. The rigors of the golden triangle of constitution, you have to form a diversion to this. There has to be an intelligible differential that has to be created. But somehow in these kind of laws, even the aim was that it has to be carved out. There are many judgments in which there's a lot of unnecessary judicial intervention has taken place. And somehow that has derailed the entire process of the code and the objective of the code, with which it was implemented in first place. So talking about the constitutional validity, the task before it was upheld by the Supreme Court, and Supreme Court said that the IBBI, who is the concerned regulator, has actually drafted a very nice code, and at the same time, all the important things were upheld between Section 95 to 100. And conclusion was also that no judicial adjudication is involved at the stages envisaged in Section 95 to 99 of the IBC. The resolution professional appointed under Section 97 serves as a facilitative role, like what we just discussed. And the report to be submitted to the adjudicating authorities recommendatory in nature. Again, it is not binding on the other stakeholders. It is incorrect to hold that hearing conducted by the adjudicating authority for the purpose of determining the jurisdictional facts at the stage when it appoints the RP under Section 97.5 of the Code. No such adjudicatory function is contemplated at that stage. Again, this is something which we have discussed. The resolution professional may exercise the powers vested under Section 99(4) of the Code for the purpose of examining the application and to seek information on matters relevant to the application from the debtor, creditor, or third-party sense roving ones. As the debtor is not deprived of an opportunity to participate in the process of the examination of the application by the RP, there is no violation of natural justice. The Supreme Court also held that just because your interim moratorium is taking place, just because the resolution professional is asking you for some kind of an information, it doesn't mean that it is a violation of natural justice, or it is a violation of due process of law that is happening. No judicial determination takes place until the adjudicating authority decides under Section 100 whether to accept or to reject the application. The report of the resolution professional is only recommendatory. The adjudicating authority must observe the principle of natural justice while accepting or rejecting the application in exercise of power under Section 100 of the Code. At that time, Supreme Court has to the adjudicating authority has to examine whether the natural justice process has been followed. The purpose of the interim moratorium under Section 96 is to protect the debtor for further legal proceedings. And the provisions of Section 95 to Section 100 are not unconstitutional, as they do not violate Article 14 and 21 of the Indian Constitution. Now, the Supreme Court sealed. Supreme Court said that these provisions are absolutely constitutional, and personal insolvency can be initiated now with full force. Now, what started after that? Now, after that, banks became very smart. The financial institutions became very smart. And rather than taking the route of CIRP, they immediately started filing personal insolvency cases against the corporate debtors and against the guarantors. Now, this led to plethora of cases, multiple number of cases. And this again led to a lot of confusion, which is still prevailing, because the court has settled one point of law, one phase of law. But at the same point of time, it is still not clear on how this whole process, the whole mechanism is going to unfold in terms of its practical implementation. Because you have a clear, because in the past also, if we talk about judgments before Dilip B. Jivrajka, there were many other judgments like Mahindra Jajodia, Lalit Kumar Jain. They also had not cleared a lot of things, that how these proceedings have to be followed. Because again, in every judgment, there was some difference or the other. Like for instance, in there was a circular, there was a notification that had come in December 2019, which was the first notification pertaining to how the PG to CD cases would be followed. That notification again, its constitutionality was upheld in Lalit Kumar Jain's case. But the point remained that how it is going to take place, what are going to be the effect, and will bank be ever be able to realize the maximization? Because again, the whole objective of going behind a personal guarantor was not to get settled at a large amount of haircut, ultimately increasing the realization and ultimately increasing the amount that bank can get. Now, that is something which was discussed, and something which is again in the entire scheme of things. There are many cases that are pending. NCLT is flooded with a lot of PG to CD cases at the moment. But at the same point of time, because of either a already existing CIRP case which is going on, the cases are not being clubbed. The idea of legislature in the beginning was to club the cases eventually, because that was the reason why the notification had come. Even in the case of Lalit Kumar Jain, it was held by the Supreme Court when they were tried to settle the position that you have a CIRP case which is pending since a long time. You file a case in the NCLT, which is the adjudicating authority, and then get both the cases clubbed. But here, what happened was most of these institutions they did not file the main Section 7 petition, or they did not chose to go under the CIRP process because they felt somewhere as a creditor, they have good chance going against the properties here of the guarantor. But again, it became a problem, and again, it was a diversion from the ultimate objective of the court. So everybody is trying as a stakeholder to somehow that I just want to get my pie anyhow. The revival of the business, the rehabilitation of the business has again gone for the toss. Lalit Kumar Jain's judgment also held that the moment the CIRP process is completed, it does not absolve the liability of the guarantor. So even let's say the moment आपका corporate insolvency resolution process खत्म हो जाता है, तो जो liability होती है promoter की, जो debtor की, वो खत्म हो जाती है, because now again it is a clean slate as per the section 32 of the IBC. But here, the liability of the guarantor, because of the contract of guarantee, and like I would have said, that the liability is again coextensive in the nature. Even after your corporate insolvency resolution process is over, your liability of the guarantor doesn't absolve. It still the people, the scholars who are studying IBC, how to get away with that. So these are the broad structures. These are the broad things which one has to understand about the personal insolvency. And also, I will be sharing the list of cases which one should be reading, especially the important sections are section 61, 60 subclause 1, 60 subclause 2, 60 subclause 3, because these are the sections which have been dealt in detail in Mahindra Kumar's Jajodia judgment as well as in Lalit Kumar Jain's judgment. And in the aftermath, because these judgments are of 2022 and Dilip G. Rajka's judgment was in 2023, which had sealed the constitutionality of section 95-200. So these are the judgments which one should read in detail to understand how the personal insolvency is implemented in the Indian context. I open the session for the questions and answers. So anybody who has a question, I think it will be better that we make it more interactive, because otherwise it will become extremely theoretical. So anybody who has a question can definitely ask, and I would love to answer that.
Yes, if you have any question, you can unmute yourself and ask. And please do it one by one to avoid any kind of chaos.
Yeah, anybody has a question?
Okay. So there's a
Case
question.
number. I can share the citation. I'll share it with Akshay, so he can definitely circulate it to you. That is something which should not be a problem. And I think you can just Google it down. You just Google Dilip Jivraj ka judgment. I think it will come. Everything is there. Anything pertaining to the subject which you want to ask, pertaining to how what else happens about the liability structure, about the right of subrogation. Any question anybody has on this subject? Personal insolvency under IBC. What is the sorry, personal insolvency? Okay, we have a question from Harry Joseph. Personal insolvency under IBC. What is the root of cause? What do you have to say? No, the root of cause is nothing like, because the institutions, the banks, the lenders, creditors, they are not able to get the, let's say, for example, they have lent the amount of 100 rupees. By the time the company goes under resolution or goes under CIRP process, your with interest, your loan becomes 130 rupees. Today, under the CIRP process, you get a resolution applicant who's ready to pay a certain amount. But he knows he's not going to pay you 130 rupees directly, because he would always want कि मुझे 130 रुपए का जो सामान है जो इनको चाहिए बैंक को, मुझे वो 60 या 70 रुपए में मिल जाए. So I should get it under the rupees 60 or 70, because he's not out there to do a social service. He's ultimately a businessman. Again, I'm explaining you in a very layman language. So let's say if he's not able to recover the amount, the bank is not able to recover the amount, then what extra they have, so which on which they can trust and they can get the realization. So that is where this provision comes into the picture. I hope I made it clear. Now I have another question. Seems a little longer. Greetings to you, sir, Vidanshu. Whether the director of a company can file a personal insolvency at the time of personal insolvency at the time the director and the company is being charged under the law like SARFAESI. So in this situation, can filing a personal insolvency? So it's a very settled position which Section 238A of the IBC talks about. It's a non-obstantive clause and it has an overriding effect. So the moment you have a IBC proceeding going on, IBC proceeding being initiated, it overpowers it overrides all the other laws. So that is a settled position. So Section 238A moment it clears all the doubts pertaining to any PMLA case which is pending, for that matter, any SARFAESI proceeding, any arbitration proceeding which is pending in terms of recovery. IBC has an overriding effect over all other laws. Any other question? V. Sundesan, what is the legal action under such circumstances? I didn't get the question, sir. Could you just elaborate a little more? If sir can be unmuted, Akshay, just check once.
Yes, sir. विदांशु के ऊपर उनका एक क्वेश्चन है. If a person intentionally declare insolvency through he is not a proper, can be considered a insolvent.
So if a person intentionally declares insolvency,
Yes.
he is not a pauper. So if he's not a pauper, why is he declaring insolvency in first place? If he doesn't have money to pay to others, then only he will declare insolvency. Yeah, so one has to one will only declare himself or herself insolvent when they cannot pay money back to their creditors. If they have the ability to pay, then why would they seek the shelter? At the same time, I think yeah, so that's what. Any other question anybody would like to ask? Anything pertaining to the applicability, anything pertaining to uh, the implementation? Yeah, anybody wants to ask and they can directly ask. What is the procedure to declare insolvency? So there are many processes. So what you are asking is basically is a voluntary liquidation. One can seek where they want to just directors decide and they chose that they want to wind up the company. And to declare insolvency, again, like I said, insolvency is generally not declared by a company. It is basically an application which is moved by the creditor. It can be an operational creditor in terms of goods and services which he's providing to the company and he has not been paid. At the same time, it can also be a financial creditor like a bank or a financial institution who also has an edge as per the Swiss ribbon case that the financial creditor's position is more serious and is more solidified in terms of getting the money. He always has a first right to recover compared to an operational creditor. So if they file a Section 7 and Section 9 application respectively, process of insolvency can be initiated. And then you have a process of, there are many other processes. I mean, today we are only specifically dealing with uh, personal insolvency. Now you have a pre-pack insolvency in place. You have fast track insolvency in place. You have a corporate insolvency resolution in process in place. So these are the broad insolvency processes which one follows to get the money back. Anybody else would like to?
There is question from Bhuvnesh Yadav. How much time does it generally take to complete the insolvency proceedings?
If it's a corporate insolvency resolution process, it may take up to as per the notification which was uh, filed by the IBC in 2020 in the aftermath of the COVID. Earlier it was 270 days, but again the problem is, Bhuvnesh, that none of these timelines are meted out in practicality because even it takes almost a couple of years for NCLT to even admit a petition. The problem is the infrastructure which we have in Indian NCL in tribunals, especially in the NCLTs. It's least to say it is extremely pathetic. And even your resolution process, which is supposed to be cleared within 3 months, it almost takes a couple of years at times, to get approvals. So, though on paper it is a very time-bound process, but in practicality, uh, nobody can tell you. I mean, the courts in NCLTs, especially in Bombay, Delhi, Bangalore, are still fine relatively. But if you go to the NCLTs in South, in cities like Kochi, in cities like in Jaipur for that matter, for Allahabad for that matter, it takes a lot of time for the NCLT, the CIRP process to get completed. And in the absence, let's say if CIRP process is not followed, if you don't get a resolution process approved, then in that scenario, the company goes under the liquidation, and it again takes another couple of years, through auction processes, through biddings, and so as to speak to get the amount realized by the banks. And banks generally at this time, I'll tell you, because I generally deal with a lot of banks and financial institutions. Banks these days are not very bullish on the CIRP process. They rather choose to go for the PG to CD process, what we are discussing right now. But banks have kind of lost faith in the resolution because ultimately they feel that they can directly restructure the account. They can, uh, reconvert the lending terms in terms of, they can waive some interest. So the whole process has become actually more good for the lawyers and the resolution professionals, so as to speak. But at the same point of time, the main stakeholders like banks and financial institutions, they are extremely, I would say, disappointed with the way the timelines are not matched and the way they're not getting the realization. Anybody else? Again, anybody can ask directly question. They don't need to write. They can just directly pose the question, and I would love to answer.
Okay, so there's a question. Please summarize the role of resolution professional.
Like I told you, the resolution professional's role is absolutely contra-distinguished in the case of a CIRP vis-a-vis in the case of a personal insolvency. In personal insolvency, it is more of a facilitative role. It is more of a recommendatory role. It is not at all an adjudicating role, which one would speak about. But however, in the case of in the CIRP, it is a little bit adjudicating also. However, you already have a settled judgment, like I told you in the Swiss Ribbon case, which is again one of the most landmark judgment in the insolvency landscape. It talks about that, and even in the case of Committee of Creditors of SR Steel versus Satish Gupta, it was held that the role of the resolution professional is absolutely administrative in nature. It cannot be adjudicatory in nature. Anybody else?
Good morning, sir. Sorry, good evening, sir. So, my question is, what is the main basic difference between an insolvency professional and when an IRP is appointed as a bankruptcy trustee? What is how a role gets changed in those assignments? When either he is a bankruptcy trustee or he's an IRP or IP.
Absolutely different domain altogether. Bankruptcy trustee is somebody who's has got a very different role to play. The interim resolution professional is appointed initially at the stage when the CIRP is getting admitted. So the IRP is basically, I would say, the first person who takes over the management of the company away from the person who's the directors, the suspended directors who basically have to leave the functioning of the company, the promoters who have to leave the functioning of the company the moment
Right.
CIRP is admitted.
And kindly provide insight on bankruptcy trustee also. Once an IRP, if I am an IRP, I am appointed as a bankruptcy trustee. What is my role there regard a personal individual?
Regarding?
A personal individual who has filed or an insolvency petition has been filed and
exactly. So that comes at a very later stage, but the bankruptcy trustee has to basically assure that the moment the bankruptcy is declared, the bankruptcy basically stamps the legal process on an insolvent. So the moment the company is declared bankrupt, the trustee basically ensures that all the claims are verified, all the claims are paid to the people who are, and at the same time, the promoter, the concerned person, the corporate debtor of the company also has a shield in terms of not getting attacked legally by any other third party in the aftermath. So that is what the main role of the bankruptcy trustee is.
Okay, and when it comes to individual person, then like you have made me understand that what is the role of bankruptcy trustee qua a corporate debtor, that is a company. But
Yes, yes.
when it comes to individual,
In the
then
DRT, yeah.
okay, in DRT, yes. So what is the same role is there? Claim and all, inviting claim.
Yes.
Okay. Thank you, sir.
The only thing is the adjudicating authority in the case of an individual and in the partnership firm is a DRT. In the case of a corporate debtor, in case of a company, it is NCLT.
But the procedure and power will be same. Role will be same.
Same.
Okay, sir. Thank you, sir. Thank you, sir.
Any other question?
If there's no question, then I think we can wind up now.